I do have skills that make me a nightmare for people like you.
Thought I'd add some little helpful tips for all those people out there too. Now, if you want to keep track of all your incoming and outgoing phone calls, not something that you have to quickly press any button or anything, download a program called Automatic Call Recorder. It's a red icon with a green handset in it. Once you've run that program, initially run it and set up where you're going to store all of the call recordings, that will keep track of every single phone call in and out of your phone. It's excellent for keeping track of phone calls to government departments, and that way there's no confusion. If you're out and about and they catch you unawares and ring you when you're in the middle of something, you still have record. It keeps track of the number, the ingoing or outgoing number. It keeps track of the time and date. So there is no confusion. It keeps a perfect log. So that's one little tip. Secondly, if you're somewhere, hypothetically saying in a courtroom, and you shouldn't have your phones on, even though lawyers and prosecutors tend to they even take phone calls in the middle of court hearings, even though you're supposed to not have your phones on, there's a little function on most people's phones called flight mode. Now, perhaps you might not have a video recorder going, but you might want to keep audio record of whatever's happening depending on the situation that you're in. If you put it onto flight mode and then set your normal phone, most phones come with an audio recorder as one of the pre-built apps in the phones that come with them. You just start up your audio recorder after you've put it in flight mode. Most things that happen is that you'll be halfway through an audio recorder and you'll have an incoming call, and that'll either stop the video from doing whatever it's doing, or it'll stop the camera, or it'll stop the audio recorder from kicking in. So if you put it in flight mode, no incoming calls or messages are going to interfere with what you've got it set doing. A good little tip. Obviously, if you're somewhere your phone should be off, putting it in flight mode certainly stops anybody from ringing you and giving away that your phone's on where it shouldn't be. Anyway, that's my little tip for the day. Stay out there and record everything. I was sent a link from a friend, Jackie, down in Christchurch. G'day, darling. And yeah, she tagged me in this link, and it's a story on stuff.co.nz about police getting racked over the knuckles for threatening to ticket a kid that wouldn't stop recording them while they'd pulled them over. Something to do with restricted licenses and all the rest of it. Again, police have pretty wide discretion as to how they want to handle those sorts of things, but what they don't have is the right to tell anybody not to record them, because in the course of their official duties they should be held accountable, and a camera will always make either a public servant or a public official more honest. And I'm not saying that to say that they're all dishonest, but they will certainly give you a better performance if they know there's a camera keeping them accountable. I mean, naturally they're being recorded everywhere they go, all around public buildings. There's security cameras everywhere, but it's who controls the footage that really gets their bees in a bonnet sometime. So remember that also. Just in case Vanessa thinks, we're just going to drag him through a bit more and waste more of his time and money and efforts, take him through half the process and then we'll withdraw halfway through. Bear in mind that once the proceedings have started, the prosecution can no longer withdraw. They must be dismissed with consent, so to speak, or it must be dismissed by the judge, because once a trial has occurred, the prosecution can no longer withdraw. It is only pre-trial that the prosecution has the ability to withdraw. As to correspondence in regards to Waitakere District Court to Phillipa in regards to recording. As I've probably already said, I got an email from Phillipa here on the 24th of December. Good afternoon, Mr. Keane. Your request to film your matter being held at the 25th of the 1st night 2019 has been referred a district judge who has declined your application. So I'm supposed to just accept that as that's that, without any evidence of what she's saying or anything whatsoever. I don't accept someone just telling me something. I need facts and evidence to support what he was being told. So that was her then. So on the 24th of December, I respond back to Phillipa with, "Greetings, Phillipa. Happy Xmas Eve. Thank you for letting us know. However, as you have not specified whom the apparent district court judge was that has declined our request upon your referral, and this officer, by making such a denial, is infringing on our rights as a party to these proceedings to keep an independent and impartial record of this matter, nor have you supplied anything in writing supporting such a denial of our rights, our request remains. To be certain, we will make another application. If what you have informed us is correct, then the district court judge should have no problem supporting this denial of rights in writing, identifying who or she is with a signature for reverse liability. So a formal JCC complaint can be lodged against him or her for their denial. As we have not attended any hearing as yet, nor has any discussion been made towards this request, the district court judge's denial is of no relevance to us. We would note that you have not addressed our questions in regards to having a transcript of the matter set for the 25th of January 2018. How is it that you can record with the court audio recording system, yet we are denied the same ability? Is transparency and accountability not appreciated in a fair and independent and impartial public hearing? Perhaps if the unidentified judicial officer show where he or she derives authority over our actions. Does Waitakere District Court not like accountability? Is there something that DCJ has a concern over? What is the mystery DCJ's reasonable grounds to deny our rights to keep record of this matter? What is the mystery DCJ's or District Court judges' reasonable grounds to deny our rights to keep a record of this matter? Is the New Zealand Bill of Rights Act 1990 not applicable at Waitakere District Courts? As we have been informed that our request for hearing is deemed to be a not guilty plea by Vanessa Olivia, according to legislation, what is the purpose of this hearing? To have us enter a formal plea on the record, making Vanessa's point irrelevant? Or could it be to gain jurisdiction in the matter? We look forward to your answers if you have any. Otherwise, expect another request to be filed prior to the 25th of January, as an unnamed district court judge has no authority to deny our rights, especially if they are scared to take responsibility for their actions. It is simply due to the incompetence of court staff, judicial officers, and lack of accountability, given you are exempt from civil proceedings due to such incompetence, that we wish to keep our own records. Either way, the general public will judge irrespective of how much the Ministry of Justice wishes to covet their actions. We do appreciate your efforts and comprehend you are just a small cog in a big, corrupt revenue-making machine. We spoke to the police yesterday with regards to the harassment we have endured already by your court security officers, and were informed to call 111 should another instance of harassment happen. And should a CSO do so upon our appearance, they will be arrested, and I mean to say detained, by us under the Crimes Act section 1961 section 42 and held until a constable can attend. Please ensure they do not overstep their powers or duty. Should they be unclear, we will have a copy for their education if required. Now, if you could supply something in writing, such as a minute from the Mystery DCJ in relation to the denial of our application, and identify the judicial officer without delay, that would be greatly appreciated. If not, the public can judge regardless. How much trust and confidence the general public have in the judicial system may suffer either way. Warmest regards, unless if it actually exists at all, warmest regards and have a great Christmas and see you in the new year. Me. P.S. We did not at any time apply to film. We wish to digitally video and audio record the matter. No one uses film anymore. Okay. Now, that was on the 24th of December. On the 22nd of January, I get a response from Phillipa. Good afternoon, Mr. Keane. G'day, Phil. I am advised that the appearance in the JP list on the 25th is to take a plea, and that if the plea is not guilty, that the matter will be remanded or for a hearing before a district court judge. So they're going to put a parking infringement or an alleged parking offence, stationary vehicle offence, in front of a district court judge. Cool! I find judges far more easy to deal with than uneducated, ignorant justices of the peace that are not legally trained. But that's good, at a date yet to be determined. That's if a not guilty plea is entered. Judge Glubb, that's Kevin Glubb, was the judge who declined your application to record your JP list appearance. His decision is recorded in a notation that says, application to record proceedings is declined. The court has recording facilities and they will be utilised. Okay, so that's what is written in the scribble that I'm going to show you in a second. I will ensure the court taker on the day has relevant recording facilities running and will have them tested before the start of the day. If you are dissatisfied with that decision, you may wish to seek legal advice about your opinions for challenging it. Really. So she's assuring me that they're going to have the machine tested. She's assuring me that it will be in operation. Just as Judge Mathers on the 9th of February 2018 assured me by leaning forward and saying to the court taker, is the court audio system recording in operation? And the court taker saying, yes, Your Honour, verifying on the day at that time that it was working, and still 5 hours later lose the entire trial. Then Phillipa's little comment about having shit tested first and whatnot doesn't really fill me with any confidence whatsoever, because I've had a judge in front of me on the day say, I'll check its recording, check with the court taker in front of her, get told yes, and then only to get a minute 1 week later from that judge saying, due to human error, oh, it appears it wasn't going. So does that mean the court taker that turned around and said, yes, Your Honour, it's an operation, does that mean he lied? But it doesn't matter. They're immune. So who cares? And they won't give up the information of who that person was. Hell no. Go hide behind those skirt tails and those aprons. Unbelievable. So, I'm sorry, but telling me something's going to get tested and ensure it's working means fuck all to me when the Ministry of Justice has already proven to me otherwise that they don't give a fuck what happens because there's no accountability. They've spouted off they're all immune, so who cares? They can just make an error. There's no recourse. It's ridiculous. Anyway, so this is my response to that email from Phillipa. Good morning, Phillipa, and this was yesterday. Thank you for supplying the name of the judge that, according to yourself, has declined our application to record the date dated the 25th of the 11th, 2018. You state Judge Glubb's decision in record in a notation that says application to record proceedings is declined. The court has recording facilities and they will be utilised. Please supply a copy of this notation, minute, direction or decision, as we have no record of the decision and will require it to file a complaint to the JCC against Judge Glubb for infringing upon our right as a party to keep an independent and impartial record of this matter. Thank you for ensuring the CARS or court audio recording system is tested before the start of court day. However, irrespective of any assurances you may be offering, this does not satisfy our request to keep an independent and impartial record ourselves. As in previous matters before the court takers, even after confirming that the CARS was in operation, ADC managed to lose an entire 5-hour hearing, even after being confirmed at the start of the proceedings that the audio recording system was functioning and active. Therefore, we have little to no trust and confidence in the court's ability to keep such records. See Police v. Keane 2018. Although our YouTube channel has far more comprehensive records of that matter, which was dismissed by consent after 10 months and 4 appearances due to that court's systematic and systemic failures during that matter. We have no wish to seek advice from a member of the New Zealand Law Society whose first duty is to the court and not ourselves. We also have no wish to challenge anything. We simply wish to maintain and exercise our affirmed rights and freedoms within the New Zealand Bill of Rights Act 1990 Section 14. It would appear that Waitakere District Court and Judge Glubb does not support these rights and freedoms, and the public record shall reflect this, irrespective of what the court record may show. Do the New Zealand Bill of Rights not apply at Waitakere District Court? Does Waitakere District Court not recognise these rights in the interest of a fair and open justice? Why has Judge Glubb denied our right to keep an independent record? Our purpose for attending on the 25th of January 2019 is to be fully informed of the cause and nature of the allegation made by Auckland Transport and to exercise and maintain our rights. A voluntary and willing plea may be entered should this happen. We cannot be dissatisfied with Judge Glubb's alleged decision as we have no record of it other than what you have informed us without any evidence. As in previous matters, we have been given false information from court staff who enjoy the immunity from any error or omission. We require proof. It is that simple, Phillipa. We have not had any response in relation to our second application notice to exercise pre-existing rights and freedoms dated the 30th of December 2018, and this shall be discussed further on the 25th of January with the presiding judicial officer. Irrespective of what you allege Judge Glubb has decided, does Judge Glubb not respect or honour the New Zealand Bill of Rights? We shall seek the answers to the above questions in due course to be imparted to the general public in whichever form we see fit in the future. Now, if you could be so kind as to provide evidence of Judge Glubb's decision, along with the reasons and or grounds for his or her denial of our rights, that would be fantastic. We shall continue to exercise and maintain all rights affirmed whenever we see fit to do so, and would appreciate fair and open justice, though we are aware that New Zealand has a legal system and not a justice system, according to Minister Judith Collins. We shall make our own justice irrespective and require the presiding judicial officer to remain fair, independent and impartial in relation to the upcoming matter on Friday. See you then with some answers, hopefully me. Here is Phillipa's response on yesterday, on the January 23rd. Good afternoon, Mr. Keane. I have attached a copy of Judge Glubb's notation and related documents. As you will see, S. Hayworth, JP, formed a preliminary view, outlined a draft decision, and then asked that it be referred to a judge for determination. I cannot comment on the judge's decision or his reasons. His decision stands unless and until it is overruled by a more senior court. Don't worry, I will be putting an appeal into a senior court. Your second application of 30 December 2018 cannot be accepted because it relates to a matter that has already been adjudicated on. Really? They just go ahead and make a decision without even discussing it. Your only opinion is to seek review of Judge Glubb's decision. You may wish to seek independent legal advice about how you would do that. I may do. And that was from Phillipa. And she has supplied the referral to the judge. I'm going to read this to you. Now, this the referral to judge or decision by Judge Glubb was made on the 24th of December, just a mere 29 days before she decided to actually tell me who it was and supply any evidence. Alright, so it's taken them a month for her to supply this. This should have been supplied in response to my request. I shouldn't have had to just been told something over an email and had to accept it. You supply the shit. It makes you more credible to actually back shit with facts. Dated 24th of December 2018. Judge Glubb. Application for Film JP JAT hearing. The above proceedings have been referred for consideration for the following reasons. Court Services Manager needs a judge to approve this request. Background. There's background. Mr. Keane has a hearing in the JP List Court on the 25th of January 2019 for a matter with Auckland Transport. He has made an application to film the hearing. No, I haven't. I've made an application to digitally and audio video record it. Nobody uses film. Perhaps that's just the legal term. Film relates to digital and video audio recording. There'll be a definition and interpretations of an act somewhere, no doubt, stating that. Probably broadcasting standards or some crap like that. Initially, the matter was referred to the JP Hayworth, who's sitting that day. Really? Now, I've been told so many times before, we don't know who's sitting on the day until the day. So another lie, because clearly you know who's sitting, and this was dated the 24th of December, and his little draft was on the 7th of December, so they knew at least 6 weeks prior who's sitting on that day. So them telling me in previous occasions when I've actually asked for the identity of the judicial officer presiding, and they say, we can't tell you that on the day until the day, and then when you go and ask, they still won't tell you. So you have to walk into a courtroom and ask physically someone who's the sitting judge, or JP. This proves they know at least 6 weeks beforehand who's sitting what day in what courtroom. End of story. We'll broach the bias and unimpartiality of Selwyn, that's S. Hayworth, that's JP, president of Auckland JP Association, the same guy who wouldn't pay his invoice for the orders he gave me to take down YouTube videos from the 19th of May 2015 in regards to my friend Neil Winterbottom's allegations. He didn't, and just was not interested whatsoever in hearing anything about the fact that Neil drove over my foot and caused me injury. No, we were there solely for the allegations that were there. And I get that now. And I am a shitload wiser than I was then. I realised the mistakes I made that day. And I realised the mistakes he too made. This court security held the court door shut while the registrar or court taker was ordered by JP Hayworth, Selwyn, to make me delete my footage. All footage that I'd recorded that day on my phone, they made me delete. While the court security held the door shut, they would not let me leave until I did that. He then gave me a pre-authored document and ordered me to sign it or be held in contempt. A document I never wrote, and yet it appears to be written by me, that he had pre-written before I attended. Not very impartial, certainly not unbiased. So, I already know Selwyn. You know, it's one of those things that people need to be aware of. You are told stuff from the courts time and time again when you go seeking for information. Nah, sorry. But then you look at the evidence that's actually supplied and it tells a different story without them even opening their mouths to lie about it. But as to impartial, Selwyn, to me, even though he gave $100 off the last infringement hearing, $70 off it, Selwyn to me is in no way impartial. I had the Ministry of Justice's senior legal team sending me letters telling me that I had no merit in my claim to go to small claims court for the unpaid invoice that he gave me. He gave me orders to remove my videos. I removed them. Fortunately, there was nothing on the document stating that I couldn't just go ahead and re-upload them afterwards, which I did. But order was complied with. They were removed. I'll move on. Sorry about the little rant. Initially, the matter was referred to the JP Hayworth who was sitting that day. We attached his response. He recommends that this matter is referred to a judge. Okay, and then we're given this decision regarding application to record proceedings. The application, 1. Mr. Keane made application by email on November 26th of November to video record court proceedings at Waitakere District Court on the 25th of January 2019. Mr. Keane states that he has no intention to cause any disruption to any proceedings and he will act within the rules and procedures. 2. Mr. Keane recites in his attached notice that the grounds for requesting the ability to record the proceedings are A. to keep an independent and impartial record. Now, I'm referring to the actual camera, not me. A camera keeps the impartial and independent record. It's who controls the footage that might not make it impartial and independent, but the camera itself is an independent and impartial third eye, so to speak. B, for matters of public interest. We're up to part 15. I think there's public interest, judging by the hundreds of views I've had so far in the last few weeks in regards to this matter, and the resounding support for what I'm doing, and the lack of trust and confidence that seems to be reflected towards the justice system in the comments of these videos. So there's already public interest, and C, to encourage accountability and transparency of fair, impartial and open justice. That should be enough right there. But no. My considerations. Let's hear Selwyn's, shall we? 2. Any recording, audio, filming or photography within a court is at the discretion of the judicial officer who is presiding that day. Sound right, Selwyn. I am scheduled, are you, to preside in the court on 25 January 2019, and this is dated again 7th of December, some 6 weeks prior to that. 3. The scheduled appearance of Mr. Keane on January the 25th, 2019 is a first appearance on an infringement matter, and a plea will be taken. Will it? If Mr. Keane pleads guilty, sentencing is likely to be immediately followed. If Mr. Keane pleads not guilty, the matter will be adjourned for a judge-alone trial to another date in the future, so both parties have time to prepare for that hearing. 4. The judiciary is an independent and impartial body. Not unbiased though, are we? Mr. Keane has an interest in the proceedings as defendant, and therefore not independent or impartial. Okay, so as a party of the proceedings, I have a right to keep an independent record. I'm not saying I'm independent, I'm saying I need to keep an independent record from the court that clearly and repetitively have fucked up their records. 5. There appears to be no specific public interest. Selwyn, mate. Don't you remember back in 2015, before you came to be an independent and impartial adjudicator in my matter, don't you remember going onto YouTube and looking at part 3? That, you know, the video you ordered me to take down? The impartiality that you expressed by watching my YouTube channel beforehand? So you know it exists, right? Clearly there's public fucking interest then, isn't there? 2,200 subscribers are watching. So, as to your, there appears to be no special public interest. I think the only person special around here is yourself. 6. Mr. Keane is not presenting himself as an accredited member of any recognised media organisation. Everybody has the right to keep a record. Everybody has the freedom and right to seek, receive and impart informations and opinion of any kind in any form. That's the Bill of Rights verbatim, section 14. Do you not understand that, Selwyn? Decision. Application declined, and order that, and here's the kicker, underlined, no recording device capable of any audio recording, filming or photography shall be permitted to be used in court on the 25th of January 2019 or on any subsequent hearing date, if required, relating to this offence. Okay, so how is the court audio recording system going to be allowed to work if you're saying that no recording device shall be permitted to be used? So are you denying now the right for a record to be kept? Got something to hide there. Got something to fear. 8. Any violation of this order may result in any recording device being confiscated and the person using the recording device being held in contempt of court, for which penalties include a period of imprisonment or fine. So now they're just a nice little impartial, backhanded, pre-written threat of contempt there for anybody that wants to record. Fuck, I hope he doesn't take the court recorder or the court taker or the court audio recording system in contempt. You know, that just gobsmacked me when he's saying bullshit like that. Okay? Unacceptable. So, to finish off, I responded to Phillipa. My response to, after being supplied the decision and Selwyn's little review, I sent back to her yesterday at 4 o'clock in the afternoon on the 23rd. Good afternoon, Phillipa. Thank you so much for supplying what I had asked for. As we presume you are aware, if it does not exist on paper in the legal realm, it does not exist. We appreciate being informed prior to the hearing that Selwyn will be presiding. We have had interactions with himself before. Will Ron be his sidekick again? That's Ron Cave. We shall be appealing this decision with the higher court, as this directly goes against our freedom to seek, receive and impart information and opinion of any kind in any form, and let that court decide. For the meantime, we shall not record the proceedings until that appeal is heard. We note that Selwyn has stated, quote, "No recording device capable of any audio recording, filming or photography shall be permitted to be used in court on the 25th of January 2019 or any subsequent hearing date if required relating to this offence." How will Waitakere District Court be able to audio record the proceedings with this decision? How will a court of record be held if no audio record is allowed? We will be immediately requiring the transcript of this hearing scheduled for Friday the 25th of January 2019. Hopefully we will not have to talk slowly for the JP to take his notes, as has happened in previous matters with Selwyn. We would ask that Selwyn respect our rights and remain in honour. We do not appreciate the subtle threat of contempt, given that we have stated our intent is in no way to disrupt or offend the court, and apologise for any offence the court may have taken, because an apology always resets any contempt, doesn't it? We shall leave our decision as to the possible bias and impartiality of Selwyn for a later date, given our previous dealings with him. Our membership of any accredited media is of no relevance. As to the public interest, there is a lot, irrespective of Selwyn's opinion, as of the ramifications of Auckland Transport having been unlawfully issuing tickets against their own procedures and guidelines to unsuspecting and trusting road users for months could be of great importance to the public as a whole. And the many members of the public who we have discussed this with are in agreement with us, so we shall let opinions vary and keep Selwyn's in the minority. The fact that Selwyn has referred this to a judge-alone trial is somewhat pleasing, should a not guilty plea be entered. Still uncertain as to how it will be recorded, given Selwyn's decision. We shall continue to keep a record independent from Waitakere District Court of this matter, for all to see. How the court and its officers behave will be reflected in the future regardless, as public trust and confidence is paramount, is it not? So many times in the past we have asked prior to hearings for the identity of presiding judicial officer prior to attending, and every time have been denied, given excuse after excuse. This time we don't ask and you freely supply it. Fantastic. We shall remember this method in future. Many thanks. Our only concern now lays with how professional Waitakere District Court's court security officers will act. Given the past instances we have recorded of their unreasonable expectations and chasing members of the public down the footpath looking for an altercation, we maintain that if any CSO oversteps or further harasses us on attendance, they will be detained under the Crimes Act 1961 Section 42 until custody can be given to a constable. Enjoy the rest of your day. Many thanks for all the information we have finally received. Me. And that's where we're leaving it. Next up, tomorrow, I'm going to go to court. I'm not going to cause any disruption. That's not my intent. I basically just want to be fully and fairly informed. I want to discuss the reasoning behind why open and fair court of justice doesn't like being open, fair and transparent. If he doesn't want to discuss that, that's fine, Selwyn. But at the end of the day, I'm going to be there with bells on. And if the court security take issue with my not a court security officer auditor Ghostbuster sign round the crest jumper, well, I'll be sure to have the emails from Chris Hurd, Senior MOJ Solicitor, that state the Ministry is satisfied with the alterations that I have done to my jumper and it is perfectly okay to wear in public, should they have an issue. Anyway, hopefully I am going to get all of this produced and uploaded before the commencement of the first hearing. Once the proceedings are commenced, I'm choosing not to post anything until the conclusion, because you might get smack on the hand for discussing an active court proceedings in the general public, even though the police do it all the time to small 15 and 16-year-old autistic children that they allege caused bodily harm. Or I mean, I don't know if you guys have followed the Christchurch Drown Me case, but I have for well over the last year, and the way the police and the media publicly persecuted at least one of the families that I've been in direct contact with is unbelievable. Shame on the Christchurch Star, shame on all of those media organisations that publicly caused over 7,000 instances of harassment to that family. Small community, everyone knows each other. I am totally disgusted with the media and the police. The police have a media centre, and yet the media were talking directly to the police without the media centre being involved, and then publishing allegations. And I would point out the word alleged never came into it. It was all posed as fact that 4 kids tried to drown another kid in a culvert. It's called the Christchurch Drowning case. Look into it. I have a lot of information in regards to that one, and I am totally shocked. Spoke to one of the people there yesterday. She rang me last night to give me a little update, and I'm still gobsmacked. They're still going to be spending months and months through all of the bullshit for something her son didn't do. Unbelievable. So even though she's trying to teach her kid the difference between right and wrong, they're getting told to say sorry for something he didn't do. So they're asking him to lie to keep the justice system happy. How's that work? You know, isn't truth, the whole truth, nothing but the truth, the whole fucking point of it? But again, we live in a legal system, not a justice system. Anyway, catch up with you all. Be cool to after school. Bye.